I just am so happy to have today with us Nisha Ajmani, who is a staff attorney at Housing for Economic Rights Advocates, HERA. And she focuses her work on tenant advocacy, including helping tenants resolve issues related to credit reporting, debt collection, housing discrimination, habitability, and landlord disputes. Prior to joining HERA, Nisha was a housing staff attorney at Family Violence Center in Oakland, where she advocated on behalf of domestic violence survivors who are dealing with housing legal issues. And her work there included in-court representation of survivors in obtaining restraining and move-out orders and defending against evictions. Nisha has also spent a substantial portion of her legal career advocating on behalf of system-involved youth. And she was a summer legal intern at HERA in 2011 and earned a postgraduate attorney fellowship at HERA in 2013, having earned her JD in 2012. So we're so happy to have Nisha here, and I wanted to let you all know we will be having a virtual office hour with Nisha. So if you have your question isn't answered, or you have something more specific, a specific question around a specific client, we ask that we won't get to those specific things today about a specific client, but we will be having a virtual office hour on, Leah, I'm hunting to you to see if you remember, it's the 14th or the 21st is our virtual office hour, or maybe Nisha, you recall, so we make sure, we'll send out an invitation to people for it, but we love these office hours, an opportunity for people to connect with the trainer directly and have questions answered. So I'll find out what that date is and be sure to tell you and put it in the chat box. But thank you so much, Nisha, for being here, and I'll go ahead and let you share your screen and take it away.
Hi, everyone. Thanks, Beth, for the intro, and thank you, Leah, as well, for helping organize all of this. I'm really excited to speak with you all today and talk more about fair housing. So let me share my PowerPoint. Okay, and then also, I believe we set the office hours for the 14th in the morning.
Awesome.
Yeah.
So the 14th, so that's this coming Monday. That's great.
Yeah.
So that's great. 10 o'clock, we'll be sending you out an invitation. Thanks, Nisha.
Yeah, no problem. Okay, hi everyone. As Beth mentioned, my name is Nisha Ajmani. I'm a staff attorney at Housing and Economic Rights Advocates in Oakland. Before I forget, I just wanted to let you all know that you're welcome to ask questions in the chat box as we go. I might not be able to get to all of them in the moment, and I might not be able to answer every question, especially personal ones. I would just caution against asking personal questions in the chat box because this isn't a confidential setting, and while I am a lawyer, I can't provide legal advice in this type of setting. So if you have a question that's personal, I welcome you to contact HERA, and I'll have the contact information for us at the end. But we're happy to answer any kind of general questions you might have, or anything that might not involve, your personal situation. And then also, I just wanted to take a moment to acknowledge the kind of crazy times we're going through right now. I'm glad the sky isn't orange today. But if you feel comfortable sharing in the chat box just where you're watching from, and just one word to describe how you're feeling, that would be great. It would be nice to get to know folks a little bit. So HERA, some of you might know somewhat about what we do. I'm the only attorney who focuses on tenant advocacy, but we have a robust legal team. We help people with all sorts of consumer issues, including debt collection, defense, credit reporting, helping folks fix their issues on credit reports, identity theft, estate planning too, and homeownership challenges, so mortgages and that sort of thing, and helping folks who are having issues paying their mortgage, or maybe you've defaulted on your mortgage. So we help folks on those issues. We serve folks statewide, so you don't have to live in Alameda County, but a large, portion of the people we serve are in the Bay Area, but we serve all throughout the state and Bay Area counties. Okay, so
getting some great comments from people. Just Nisha, people are saying they're sluggish, but they're relieved that it's cooled down, and a bit worried people are. So it's so glad you're all here and identify with what you're saying.
I definitely feel the same way. It's very odd. Thanks for sharing. Okay, so as you all know, today we're here to talk about fair housing rights and what to do if you suspect that you're being discriminated against in renting an apartment or seeking housing. So that's what I'm going to focus on today. And so what you should know is that there are federal laws that apply to all states and then also California specific laws. The California laws are pretty consistent with what the federal fair housing laws are, but California actually provides some more protections than the federal laws do. So in general, what both the federal and state housing discrimination laws say is that it's illegal to discriminate against people based on a certain set of factors in the quote provision of housing. So the red is a federal law, and then blue is California specific. But the California law overlaps with federal too. So everything that applies in federal applies to California. So federal, it's this list of items, they're called protected classes. So race, religion, color, sex, sexual orientation, marital status, national origin, ancestry, familial status. So that means kind of, how many children do you have? Are you married? That sort of thing. Disability, source of income. Source of income is, let's say you're renting an apartment or you're trying to rent an apartment and a portion of your income comes from, for example, Section 8. In California, landlords can't discriminate against you for using a voucher. So we'll talk in more detail about a lot of these later. Immigration status, that's also a California specific law, though it's possible other states have it as well. Medical condition or age. So I'll just give a few examples of what would qualify as discrimination. So for example, giving different prices to different tenants of different races, or having a higher security deposit for tenants of a certain race, or less favorable terms to those tenants as opposed to other tenants in the building. Not calling back a prospective renter because of an accent. So for example, you want to apply for an apartment that's listed on Craigslist, and the landlord hears your voice or hears your name, for example, and then just doesn't call you back or says that the apartment isn't available when it is available. Refusing to show apartments or houses in certain neighborhoods or buildings to tenants of a certain race. Representing that housing is not available when it is. And harassing a person in connection to housing. So this can take the form of sexual harassment, which, if it reaches a certain level, qualifies as discrimination against someone based on their sex. So for example, there was a case where the landlord was an owner of 50 rental properties, and he subjected women, prospective and actual tenants to discrimination and sexual harassment based on their gender. Another example is refusing to allow a person with a disability to make a reasonable modification to their rental unit. And I'll talk more in detail about people with disabilities and how the anti-discrimination laws apply to them, and how to make adjustments to your unit, what the process is. Okay, so who has to follow fair housing laws and when does it apply? This list isn't exhaustive, but it's kind of the main areas where we see it. So in general, as I mentioned earlier, the fair housing laws apply in, quote, the provision of housing, and that's pretty broad. So it applies to renting and leasing, not only when you're applying for an apartment or house, but when you're actually a tenant, sales, mortgage lending, and insurance. We won't get into mortgage lending today, but that is an area that HERA practices. So if you have questions about that, you're welcome to contact us. Advertising, so for example, Craigslist ads, it would apply there. There can't be any discrimination in advertising, and then homeowner actions. And that's also a homeowner issue, so I won't be talking about that today. Okay, so there are two main ways that people can prove that they've been discriminated against. And if you believe that you've been discriminated against, the quote unquote burden falls on you to prove that. So I'll talk more later about, good ways to address any discrimination issue you're dealing with. Documentation is really important. Okay, so the two ways are disparate treatment and disparate impact. So disparate treatment is intentional discrimination, and it might seem more obvious when it happens. So for example, let's say you go to an apartment complex and want to apply for a unit there that is available, and the landlord or property manager sees you and you're a person of color, and they say, oh, we don't rent apartments to XYZ race. So that would be a very clear example of disparate treatment. A disparate impact is when there is a neutral policy. So the landlord has a policy that is on its face, doesn't say anything about not accepting people of a certain background, but the impact of the policy affects people of a protected class, like one of the items we listed earlier, in a harmful way. So in order to prove the disparate impact theory, the tenant would have to show, you would essentially have to figure out how to do an analysis to show statistically that people, for example, of a certain race, are routinely not granted an apartment, or people with disabilities are routinely not granted a certain modification to their unit based on a strict application of a policy that the landlord has. And I'll provide more examples of this so you can understand it. But so first, the plaintiff is the tenant, would have to show that the difference in effects of the policy are actually caused by the policy that the landlord has. The second step would fall on the landlord. Let's say it's the landlord. It could be, whoever the housing provider is, who would be the quote defendant. So the landlord would have to prove that its challenged policy is needed to advance a quote legitimate interest. And then the third step is that the landlord's interest, quote, could be served by another practice that has a less discriminatory effect. So that would be on the tenant So that would be the tenant's response to the landlord's, defense, saying that there's another policy that the landlord could use, or another practice that would not have this discriminatory effect. So it's this model for proving discrimination is essentially a way of proving discrimination in a society where people often conceal their true motivation. So oftentimes, you're not, unfortunately, going to get the landlord who's just very clear in their racism. Usually it's more subtle. So that's kind of how the disparate impact theory can come into play and help. Unfortunately, this theory, disparate impact, has been chipped away at by the federal government, so it's not as strong as it used to be. So here's an example of disparate treatment from a case. This isn't a case that I've had, but a case, I believe it was in New York. So 3 Latino and 2 white current and former tenants sued the building owner, and they alleged that the landlord discriminated against the Latino residents living in the apartments for a few reasons. First, requiring only the Latino tenants to provide proof of their legal immigration status, so they didn't require the white tenants to provide that proof. By initiating frivolous eviction proceedings against Latino tenants, and by threatening and intimidating Latino tenants, and by imposing unlawful rent increases only on the Latino tenants. So in that case, the judge ruled in favor of the Latino tenants and the plaintiffs. So as I mentioned, disparate impact is a little more subtle, but here is an example of a disparate impact case. This actually was disparate impact and disparate treatment. So the landlords owned properties, and in one of the buildings, most of the tenants were African American, and the landlords enforced restrictions implemented by the previous owners, which included restrictions on children's use of the property and a 10 p.m. curfew. The landlords also imposed a rule barring anyone who had certain felony or misdemeanor convictions within the last 99 years from living in the building. So the tenants sued, claiming that the policy of disallowing convictions in the last 99 years had a disparate impact on African American prospective tenants, and they were successful on that claim. So another way that folks in California are protected against discrimination is in the domestic violence context. So this is California only. So there are a few different California laws that apply to domestic violence survivors. And if the California law doesn't apply for some reason, you can also make the argument that eviction against domestic violence survivors or discrimination violates their fair housing rights under the federal law. It's just a kind of a harder argument to make because the federal law doesn't have an explicit provision protecting domestic violence survivors. So in California, landlords, we do have a law that says landlords cannot evict tenants based on their status as a domestic violence survivor, and cannot evict tenants for police responses to their property based on domestic violence incidents. So for example, if a domestic violence survivor needs to call the police, this law is actually not super old. It's relatively recent, but it says, if you need to call the police and the police arrive at your apartment, let's say like 10 times in a week, you can't get evicted for that because you were calling to protect your safety. So a landlord cannot evict you for those phone calls to the police. And if a landlord does try to evict you for reasons related to domestic violence, under the unlawful detainer list of kind of defenses, if you, let's say you receive an eviction notice from your landlord, you could list domestic violence as a defense against the eviction. Okay, familial status. So this is federal law and California, and it prohibits landlords and housing providers from discriminating against people for their familial status, whatever that might be. So it might look like refusing to rent against children with families under 18, refusing to rent to unmarried couples, refusing to rent to households with children or kids below a certain age, or having specific rules for households with children versus households without children, unreasonable occupancy limits. So here's an example from a case that I had earlier this year. The tenant's lease was limited to one occupant. This tenant got married and wanted to have their spouse move in. I don't know that the landlord refused to allow the spouse to move in, but the fact that the lease limited the tenant to it only being my client to be able to live in the apartment is an example of a policy that could have a disparate impact on married individuals and their family status. Source of income, as I mentioned, in California, it's illegal to discriminate against folks based on their source of income. So this is also a relatively recent law in the last few years. And as I mentioned, for example, if you receive Section 8 or any other type of public housing assistance, prospective landlords cannot deny your rental application based on this fact. And then, unfortunately, source of income discrimination can also be pretext for unlawful discrimination based on other factors. So this is also an example of something that I've seen. A prospective tenant applies for an apartment, and the landlord kind of walks through the application process with this person and says they accept vouchers, and the person is tentatively approved and just goes in person to drop off paperwork, and then the landlord sees that the prospective tenant is a person of color, and then essentially changes their position and says they can't accept their application because they don't accept vouchers, when they previously accepted vouchers or told the tenant that they would. So here, this could be an example of both source of income discrimination and potentially discrimination based on race or other factors. It's, as I mentioned, I'll get into this later, but typically to have the most successful case, it's best to have as much as you can in writing. LGBTQ protections. So in California, there is explicitly LGBTQ folks are protected, but there was also a case in federal law, so not in California, but where it explicitly says that harassment by other tenants towards other tenants in the building can qualify as harassment under the Fair Housing Act, even though it wasn't necessarily the landlord that was discriminating against the tenant. In this case, the tenant was a lesbian woman and was experiencing severe harassment by other tenants in the building, and told the landlord repeatedly about what was happening. The landlord, told her she was lying, and essentially retaliated against her. So in that case, I believe she also filed allegations of intentional discrimination by the landlord, but what the court found was that the landlord was responsible for addressing the harassment by the other tenants. The landlord knew about what was happening, and as long as the landlord knew and didn't do anything about it, that was a violation of the Fair Housing Act and anti-discrimination laws. And then, so this is related, while that case was specifically about LGBTQ protections, because that was the tenant's protected class, tenant against tenant harassment can happen in all sorts of ways and factors. So while that case I just mentioned might not 100% apply to your situation, it's still like very wise if you're dealing with something like this to try to make this argument. So if you experience discrimination or harassment by another tenant, for example, they call you ethnic slurs or discriminate against you on some other factor like your religion, you do have a strong argument that the landlord is obligated to intervene and stop the other tenant's behavior. As long as you tell the landlord, you need to make it clear to the landlord that this other tenant is discriminating against you and harassing you, and it's best to put that in writing so the landlord can't come back later and say that you never told them. So have that in writing, and whether it's an email or text or letter with a date. So the landlord in most cases is obligated to do something to intervene and stop the other tenant's behavior. And that could include evicting the other tenant. So under tenant rights laws, you have a right to the quiet use and enjoyment of your residence. And if you're being harassed by other tenants, that would be a violation of this right. And so your landlord would have an obligation to ensure that this right is being acknowledged and protected. So if your landlord knows about the harassment and doesn't do anything about it, you might have legal claims against your landlord, and the landlord could be liable. Okay, so now we're gonna do a little quiz. I think Leah had set up a little poll. Yeah, so
should be able to see that poll now.
If folks can just.
And if you're on your phone and cannot see the poll, the question is, a landlord can ask prospective and current tenants what their immigration status is. And then whether that's true or false, it's going to say you could type it into the chat box if you can't do the poll. But I guess if you're on the phone, you can't type it in the chat box. So, yeah, so
I'm going to go ahead and close the poll in about 5 seconds. Sharing the results now.
Yeah, well, everybody got that right. Maybe it was too easy. Correct. So a landlord cannot ask prospective tenants what their immigration status is. So this is a California law that makes it illegal for prospective landlords to deny someone an apartment solely based on their immigration status, or to even ask about their immigration status. In California, before this law was passed, folks were seeing a lot of discrimination against people who potentially you don't have full U.S. citizenship. So thankfully they passed that law, and it's Civil Code 1940.3, in case folks want to know what the statute is. So California Civil Code 1940.3. Okay, and then we have a second question here.
Okay, the people should be able to see that second poll question. Okay, I'll give it about 5 more seconds. Sharing
Okay.
results.
Yeah, thanks. So the answer is false. This would be kind of a term that would be too restrictive on families with children. And I've seen this before in leases. So a landlord put in the lease that, kids couldn't, be outside and, be running around like normal children after 5. So that would be another example. It might be a little bit harder to prove, but it's, in our perspective, it would definitely fall under discrimination against, based on family status.
Nisha, someone's asking about the previous law you were talking about and wondering if it passed when California became a sanctuary state.
I think it was around 2008 or so that it passed.
2008. Okay.
Yeah, I would have to double check that.
Okay.
Yeah.
Thank you.
Yeah. Okay, thanks for doing that, Leah. That was interesting to see. Okay, so let's see here. Okay, so now we're going to talk about fair housing laws and people with disabilities. So under California and federal law, a housing provider must allow a, quote, person with a disability to make reasonable modifications to their rental unit, this at the tenant's expense, and to make, quote, reasonable accommodations in rules, policies, practices to allow a person with a disability equal opportunity to use and enjoy a dwelling. So it's important to note that these laws apply to people with physical disabilities, mental health disabilities, developmental disabilities. It's not just what you might expect. Sometimes people think it's only people with physical disabilities. So sometimes it's harder to see what sort of disability a person has. But just keep in mind that these laws apply to anybody with a qualified disability. So in order to get a reasonable accommodation, so as I mentioned a few moments ago, a reasonable accommodation is an adjustment to a policy that a landlord has in order to ensure that the tenant is able to have equal opportunity to use and enjoy a dwelling. So in order to get this reasonable accommodation, the tenant or prospective tenant would need to show that a requested accommodation may be necessary. There must be an identifiable relationship or quote unquote nexus between the requested accommodation and the disability. And I'll provide some examples later. It also has to be an interactive process between the prospective tenant or the tenant and the landlord. So, it can't just be you make this request and then the landlord denies it. There has to be an ongoing process. So when a housing provider denies a requested accommodation or modification, the provider needs to discuss with the tenant or prospective tenant whether there is an alternative accommodation or modification that would effectively address the requester's disability related needs. So sometimes, a tenant can say, this is what I think would help. Can you do this? Or you don't necessarily have to come up with the requested modification, though usually that is kind of how the process goes. But the point is that there needs to be a back and forth between the landlord and the tenant. And sometimes the landlord will, claim that the requested modification would kind of fundamentally alter their operations and impose, quote, an undue financial and administrative burden. So, as part of this interactive process, the housing provider needs to recognize that the individual requesting the accommodation is most familiar with his or her disability and is in the best position to determine what type of aid or service will be effective to meet their need. These discussions often result in an effective accommodation or modification for the requester that does not pose an undue financial and administrative burden for the provider. So I'll give a few examples. So let's say a housing provider has a policy of providing unassigned parking spaces to residents. A resident with a mobility impairment who is substantially limited in her ability to walk requests an assigned accessible parking space close to the entrance to her unit as a reasonable accommodation. There are available parking spaces near the entrance to her unit that are accessible, but those spaces are available to all residents on a first come, first served basis. So that's the policy, is the first come, first served basis. So in this case, the provider must make an exception to the policy of not providing assigned parking spaces. Sorry, let me back up. That was a little confusing. So the provider must make an exception to their policy about the first come, first served basis if she's a new tenant and has this disability related need. So the provider must provide a parking spot for her to accommodate this disability. Another example is a housing provider has a policy of requiring tenants to come to the rental office in person to pay their rent. A tenant has a mental disability that makes her afraid to leave her unit. Because of her disability, she requests that she may be permitted to have a friend mail her rent payment to the rental office as a reasonable accommodation. So in this case, the housing provider must accept that and make an exception to their in-person rental payment process. And then, let's see, wait a minute, I'm not sure. Oh, no, that's not. Just a few more things. If a landlord denies a requested accommodation or modification, it'll usually be on the grounds that it's an undue burden, either financially or administratively. But the housing provider needs to also, after they make that denial, ask whether the requester has, another possibility for a modification, or if there's another way to make a change that would effectively address the tenant's need.
There are a couple of questions.
Okay. Yeah.
One is, the first one came through was, can clients get application fees returned from the landlord? She says that it appears that landlords charge application fees, and even though they have no interest in renting to certain clients.
Oh, yeah, I mean, I think it would be a case-by-case basis. If you have, they collect a rental fee and and then deny without actually doing a full, assessment, like if they don't check your credit or anything along those lines. I mean, it would be, I think definitely within the realm to send a letter and ask for a return of the rental application fee. But it is kind of a case-by-case basis. Like if there's any sort of documentation or communication, written communication with the landlord. We did a presentation on this kind of more general tenant related issues related to credit and debt a while ago, and we can do something similar. HERA has a lot of information about this, but if a landlord denies your application and is just very vague about the denial, that could be a sign that it's discrimination. And I'll talk more about signs of discrimination to look out for later. But usually in those cases, what we would recommend is that you provide something in writing to the landlord requesting a letter from them or email explaining why they denied your application.
Okay.
So that way you'll have something in writing in case you need to pursue something, or if they don't respond to you, don't put anything in writing. That's also not a great sign.
Right.
You could say that, look, I sent them a letter on this date asking them to explain to me in writing why they deny my application. Then I sent a follow-up letter and made this phone call on XYZ date and they still didn't respond to me. You could use that to support any sort of
Right.
case or claim you might want to make against them.
Yeah, because it can feel kind of scammy when you fill out an application and then they don't even contact you.
Yeah. And I know they use a lot of these like tenant screening report companies that have inaccurate and false information. So
Right.
it's a huge problem. And then they have your money. So.
And then someone asked about the disability. If a person needs to get documentation from their doctor to prove, quote unquote, their disability.
Yeah. So a landlord can only ask information enough to make kind of a reasonable decision. So they can't ask you what is your disability. In some cases, they might be able to see what your disability is, and sometimes they can't. So, a letter from a doctor could help, but it's not 100% required. So a housing provider is entitled to obtain information that is necessary to evaluate whether a requested reasonable accommodation or modification may be necessary because of a disability.
So you could get a letter from your doctor just saying that you need these, these specific things to happen without saying, the doctor doesn't have to say what your disability is, just that you need to have them.
Correct. Yeah. Okay. Yes, you could do that.
All right. And then someone else asked if a landlord can ask a tenant to move out because they're going to be doing updates to the unit.
So that is, California law does allow that in some circumstances,
Okay.
But I would have to know kind of like more specifics
Okay, so that's
about
one that someone could come to the office hour to talk more about.
Yeah.
Okay, thank you.
So I just want to make sure I'm not missing anything about disability related needs and requests. So yeah, in terms of providing information to the landlord, if the landlord requests information only to the extent necessary to evaluate the modification request, the information come from the tenant or prospective tenant, a medical professional, a peer support group, a non-medical services agency, or a reliable third party who is in a position to know about the individual's disability.
Thank you.
Yeah. And then, in most cases, as I mentioned, you don't need to provide what the actual disability is in order to get a modification. Okay, so that's everything on persons with disabilities for now. I think we're now ready for a break. If folks want to take a few minutes. Hey everyone. Okay, so here's an example of a reasonable accommodation letter. It's a little template that folks can use if you're dealing with this type of issue. So as you can see, you provide your basic information and say that you have a qualifying disability as defined by the Fair Housing Amendments Act of 1988. And if the landlord has a certain policy or practice, you would want to say what that is, and then say that you need an accommodation based on your disability. And again, you don't have to have a medical provider provide a letter or provide that type of kind of supporting for you, but it can definitely help. And then kind of frame it as I would like to have an interactive discussion with you to figure out best how my needs can be met and to maintain operations for the owner. So yeah, here's an example, and I believe you all have a PowerPoint, so you should definitely keep this, and then if you ever want an attorney to review a letter before you send it, you're welcome to contact HERA. We also have other we'll have resources at the end of this discussion for Alameda County, so other organizations you can contact too. Okay, so also related to persons with disabilities, if you need a service animal or comfort animal, they're permitted under the Fair Housing Act. And then just similar as to what I discussed before, you must show why having this service animal is needed to ensure that you have an equal opportunity to use and enjoy the dwelling. And the landlord may ask for documentation of your disability and why you need the assistance of an animal.
There was a question asked, Leah, I got booted out for a second, but I'm back now. But there was a question asked about whether if someone is in a ADA unit and they were rented that unit knowing that the person did not have a disability, but then someone comes and applies for a unit and needs an ADA unit, can the person that's in the unit without a disability get kicked out? Kind of complicated. Again, it sounds like you might do individually.
Yeah, I mean, I think it would depend on a number of factors, but my first thought is no, but yeah, I would have to probably know some more information. I don't think it's possible for a landlord to just evict someone.
Yes, so I'd encourage you to come to the office hour and ask that specific question. Great, thank you.
Yeah. Okay. Okay, so fair housing and criminal record. So you can't automatically be disqualified based on having a criminal record. This is California. I know California has more specific laws and protections, but some restrictions are permitted. So that's just something to keep in mind. Okay, here's another quiz. Okay, yeah, so the answer is false. If a landlord has a strict no pets policy, a tenant, if they need a service animal, would need to kind of go through the reasonable accommodation process, but it's not possible for a landlord to just have a strict no pets policy because it would have a disparate impact on folks with disabilities. Okay, so California's UNRU Act, this is California's anti-discrimination law. We have multiple, and there are kind of some anti-discrimination provisions that have their own kind of statute that are separate, but this is one of the main California laws. So it protects against arbitrary discrimination and this discrimination based on race, color, gender, religion, ancestry, national origin, disability, sexual orientation, and medical condition. So it applies not only to housing providers, but also to banks, restaurants, hotels, religious organizations, nonprofits, and essentially all business establishments. Okay, so I know that obviously we're all going through an unprecedented pandemic right now, which is very hard for folks to deal with. Again, thank you all for being here. I know there's probably a lot on your plate. So I did want to talk a little bit about how COVID-19 is affecting fair housing and kind of the interplay and what we're seeing. So as a lot of folks probably know, is that research is showing that COVID-19 is having a disproportionate impact on people of color, people with disabilities. And then there are multiple reasons for this, which I'm sure a lot of you can probably anticipate and understand. And that's, longstanding structural discrimination against people of color in access to healthcare, housing, employment, unequal access to economic mobility, longstanding wealth disparities. So in housing, discrimination during COVID-19 might show up as using eviction moratoria exceptions as a pretext to evict tenants for discriminatory reasons. So in that, what I mean by eviction moratoria is there have been a number of local city laws and state law and federal laws that have been passed. Some of them have already expired, but they banned evictions temporarily during the COVID-19 pandemic. Some of them are still in effect, so I know it's super confusing, and we're planning to do actually another webinar on the COVID-19 eviction moratoria. The state of California recently passed a law, emergency law on this issue, but for a while, many jurisdictions, including Alameda County, which their eviction moratorium is still in effect. And so what a lot of these laws said was that landlords cannot evict tenants except for reasons related to public health and safety. So what folks might see is landlords trying to use this exception to try to claim, that certain tenants need to be evicted, but maybe there isn't really a strong claim and the landlord just wants the tenant out for discriminatory reasons, for example, race or gender or religion. So that's one way it might show up. Also, landlords not granting necessary reasonable accommodations to people with disabilities or seniors, and then also including people who contract COVID-19. Or maybe landlords just, immediately evict, try to go down that process instead of going through the reasonable accommodation discussion, which I talked about earlier. So landlords cannot require prospective tenants to disclose whether they have COVID-19. Landlords can ask prospective tenants and tenants to voluntarily say whether they have COVID-19, but they can't require them to. It would also be concerning if a landlord, asked you whether you have COVID-19 and you choose, as your right to not provide an answer, and then let's say then the landlord does something, does something in retaliation. So that would definitely be a concerning sign and something to look out for. And then also, seniors and elderly tenants, Asian tenants, prospective tenants might experience higher rates of stigmatization and harassment from landlords and other tenants. So something else to look out for, and whether it's intentional discrimination or there might be a disproportionate adverse impact on folks who are seniors, people with disabilities. So something to look out for.
So someone's asking if you could fill us in on the recent state passage of laws on evictions. It's been kind of confusing.
Yeah, it is really confusing. I can give some general information, but I would just caution you that what I give is not, I wouldn't take every word and say this is what it is, because we're still kind of figuring out how everything works together. But California recently passed a law, which the governor signed, which applies only to evictions for non-payment of rent. So all other, or I don't want to say all, but most other evictions can now go forward. But now there are specific requirements if you can't pay rent due to COVID. You know, maybe your income has been reduced or you have increased medical expenses. So now for non-payment of rent, landlords, if they, I believe they can't file until October in California, but you have across the board non-payment of rent, you have 15 days to respond instead of the normal, I think 5 days to respond to an eviction notice. But then there's also something important to keep in mind is the Center for Disease Control also just recently issued an eviction moratorium.
Right.
That goes through the end of the year. And that one actually in some cases has more protections than California does. So we're trying to kind of sort through all of that and figure out, you know, how to make sure folks are protected as much as possible, and then figuring out how, you know, the California law affects Alameda County's moratorium, because Alameda County's moratorium is actually stronger than California law because it bans all evictions temporarily, I believe, through the end of the year, except for evictions related to public health and safety. So we're trying to kind of sort through all of this. But I hope that was, you know, at least some helpful information. Another thing to keep in mind in California, landlords, while you can't be sued, I mean, you can't be evicted on non-payment of rent due to COVID. It gets pretty complicated because there's a certain kind of time frame for when rent wasn't paid. But landlords cannot sue you for that unpaid rent until March 1st. But again, there has to be a COVID related reason why you can't pay the rent in California.
Okay. Thank you.
Yeah. And I think this is something that HERA will want to do a webinar on. So, you know, we'll have our contact information.
Yeah, and let us know
up our email list or
and
something.
we'd be happy to host it.
Okay, yeah, I'll definitely let you know. Okay, so possible signs of discrimination to look out for. The landlord denies your rental application without providing a reason, or provides a vague reason, for example, just credit with nothing in writing. So you know, if a landlord says that they're denying your application because of credit, they have to provide you with something in writing saying, we're denying your application based on credit or partially based on credit, and here's how you can get a copy of your credit report. So if they don't do that and they just say credit, that's definitely a warning sign. But in general, if they just deny your application without giving you a reason, that's something to be concerned about. A landlord drags out your rental application process. The landlord's tone and treatment towards you changes once the landlord has seen you in person or has talked to you on the phone. I had a client who, when this person applied for apartments and got on the phone with the landlord and they asked, you know, about her income, she received, I believe it was SSI, because she had a mental health disability, and then their tone would just kind of change. So it could be something subtle. Definitely look out for that. And then this person was denied. So yeah, they can't, you know, as I mentioned before, they can't discriminate based on source of income, but also just kind of keep your eye out for more subtle signs. Maybe it's just a change in their tone of voice, or they just take longer to get back to you. And so that's why it's really important, as much as you can, to keep everything in writing. And then let's say you're a tenant and you have issues in your unit and you notice that the landlord responds faster to tenants who are white, and let's say you're a person of color, and the landlord responds and fixes other tenants' issues efficiently, but never, calls you back or takes a long time to fix just basic kind of issues that you have. Okay, so steps to take if you believe you're being discriminated against. As I mentioned earlier, it's really good practice to make sure all of your communications are in writing. So, for example, if your application is denied and you didn't receive a reason in writing, write to the landlord. As much as possible, try to have it so there's a date stamp and time. I know text messages can be a little tricky sometimes because the date doesn't show up, but you definitely want to use, if you're texting, like take screenshots immediately. I had a client who had texted communications with his landlord and didn't save screenshots, and apparently there are apps out there where you can actually wipe out the conversations, text conversations. So let's say I'm texting with somebody and that other person gets this, I think it's called like Wiper app or something. That person can use that Wiper app and then all the conversations are deleted from my phone. So it's really important to make copies. And so yeah, email, text, letters, and then so if you're denied, ask them to provide a statement to you in writing explaining why your application was denied. And then if they don't respond to you, follow up in writing and a phone call probably. And then if they don't respond again, that's also, a sign that they don't want to put something in writing. So document as much as possible. If it's relevant, take pictures. So for example, if there are habitability issues, if there's mold or, leaks and your landlord isn't fixing it, take pictures. And write down, if your landlord said something to you, in person, write down what the landlord said as soon as you can, or put it in an email to someone you trust. So there's a date and stamp, and just say what happened as close in time as to when it happened. And then if there are any witnesses to the discriminatory behavior, for example, a neighbor, let's say the neighbor witnessed the landlord say, call you a racial slur or something like that. Ask the witness if they would be willing to write something for you describing what they witnessed. And it's really important here to make sure that the witness is, as objective as possible, because if it does somewhere down the line go in front of a court, you want to make sure it doesn't appear that the witness is just trying to, say what you want them to say. And then, yeah, if it is, serious, definitely consider filing a complaint with the California or Federal Fair Housing Agency. And then you can also consider filing a lawsuit against the person or company who discriminated against you. And it's definitely, these two options. Well, you could do it on your own. It would probably help to speak with a lawyer first. And so, yeah, contacting a fair housing lawyer to discuss what your options are and your rights, and just to review the documents you have and evidence. Sometimes you could have a really strong case, but unfortunately there isn't anything in writing supporting that case. It doesn't mean, the discrimination didn't happen, but it can usually be harder to be successful in a lawsuit or a fair housing agency complaint without documentation. So that's why it's really important to document as much as you can. So as I mentioned, you have two kind of options if you want to take it kind of to the next level. If let's say you send a letter to your landlord and then that kind of somehow resolves the issue, that's great. But if that doesn't work, then you can definitely consider these two options. So if you want to file a lawsuit, that means suing a landlord. You have 2 years within the date of conduct. So let's say you're denied your application and you believe it's for discriminatory reasons January 2020, you would have until January 2022 to file a lawsuit. Give or take sometimes determining when the actual incident happened can be hard. Or you can file a complaint with the federal Fair Housing Department or the state Fair Housing Department. And so this is kind of a flow chart of what that would look like. You would first write like a summary of what happened, and you should probably include like dates, like on X date, the landlord said this to me, he sent me an email saying this, and then just so have a timeline of what happened and explaining why you believe this is discriminatory and what your protected class is. So what will happen is you'll file this complaint. There will be an intake with either the state agency or the federal agency, and they'll do an investigation. So that means collecting documents, interviewing you as the tenant, and the kind of legal term is the complainant. And then usually HUD, or the HUD is the federal Fair Housing Agency, so Housing and Urban Development. So HUD or the state agency will want to go through a process that's called conciliation, where they'll try to kind of encourage some sort of agreement between the tenant and the landlord. But neither side is required to agree. And then if the sides don't come to an agreement, then the agency will make a decision, either finding that there was discrimination or that there wasn't. And if they do find discrimination, HUD would represent you in a legal action, most likely, or if there's a no cause finding, then you could file your own lawsuit. You don't have to, but that could be your next step if you want to proceed. It's filing a lawsuit, it would definitely be pretty involved and require a lot of time and energies and probably emotional, involvement. So, just you would want to definitely kind of weigh kind of what the risks are and possible outcomes, and so definitely speak with an attorney before filing a lawsuit. So this is an example of what the complaint looks like for HUD. You could file it online. You could also file it by mail or call them. So this is just a screenshot of kind of how to go about the process. And this is a process for California agency about how to file a complaint. So you can file it online. You have to create an account by mail or phone or fax. You can also just call them and get more information. So options if you're a victim of housing discrimination. So working with a fair housing organization or a law firm, and use of testers are authorized. So testers are, some fair housing organizations have these, and they're people who, for example, kind of just like pretend to apply for a rental unit, and let's say they're a woman or a person of color, they'll usually go in person and just kind of test and see how the landlord responds to their application, and if the landlord is discriminating against them in any way, or maybe they'll use a certain name where the landlord might assume that this person is from a different country, and just see how the landlord responds. If they deny the application, what they do. So that's something that can help kind of build up evidence if you've been discriminated against in housing. So here are some more Alameda County resources. Of course, HERA. As I mentioned, I work on tenant issues, but we also have people who help out with homeowner issues and fair housing kind of across the board. So definitely call us if you have further questions about what we've discussed today. Disability Rights California, they focus only on people who have challenges and are facing discrimination based on disabilities. And I believe they have an office in Oakland, but check out their website for more information. They help folks not just in housing, but across many other areas too, like employment, education, that sort of thing. Echo Housing, they focus specifically on fair housing and providing counseling to folks who have been discriminated against in housing. Bay Area Legal Aid, they're a law firm, nonprofit as well. They have offices in Oakland, I believe also in Contra Costa County. I could be wrong about that, but they help folks in Alameda County and other Bay Area counties as well. And they have a tenants rights team too, and can help folks who believe they've been discriminated against in housing. And Project Sentinel, so they're mostly in the South Bay, but they do help folks in the city of Fremont who are dealing with housing discrimination, and they have lawyers there as well. I don't know if there are any folks on this call who live in Fremont, but they're an option to contact too. And then here's some more information about HERA's services. As I mentioned, we help folks with debt collection issues, student loans. We have a team who helps folks who are dealing with inability to pay back student loans, or maybe they've defaulted or went to a for-profit school and are dealing with kind of high level tactics from these debt collectors that are very predatory. Auto loans, medical debt, credit card loans as well, high cost loans, homeowner association issues, credit reporting. I also can help folks if you're a tenant with credit reporting issues. So identity theft, how to get your credit report, how to fix any issues that are on your credit report, how to understand what your credit report says. It can be complicated to read one. Even for me, it's hard for me to understand what they say a lot of the time. Let's say your landlord denies an apartment and says credit, as I mentioned before, you'll definitely want to get a copy of your credit report if that happens. And then, as I mentioned, they're required to provide you something in writing if they deny you based on your credit. Financial product recommendations, mortgages, foreclosure prevention, and mortgage servicing issues. So that's another big area that we work on. Tenants, here's kind of some of the other areas that I can help on. I believe someone raised their hand. Bobby. Yeah, I can answer your question. Not sure I can see the chat, but.
Okay, Bobby, you can unmute yourself and ask your question if you like. Or ask your question in the chat.
Looks like Bobby might be gone. Bobby, are you there? Okay, looks like Bobby's not here.
Okay, well, if Bobby comes back, I'm happy to answer their question. Okay,
Great.
Veterans and service members, a lot of these kind of areas can overlap. So, if you don't necessarily have a specific question that falls in just one category, that's totally fine. So enforcing special protections and assisting with resources for veterans and service members. And then we also provide estate planning services, simple wills and trusts. Yeah, so that's kind of a general overview of what else we do. And here's our phone number. And you're welcome to visit our website. We have a Facebook page with more information. And yeah, we're happy to answer questions you might have. We have a pretty great team, and a number of attorneys. So.
Yeah, and we have some other trainings scheduled for the rest of the year coming up with HERA covering some of these items. But if there's something in particular that you are interested in for yourself or your clients, when you complete your evaluation, there is a place for you to put information like that, of what additional trainings you'd like to see or have help with. We do have a few more minutes left, so if anyone has a question they'd like to discuss, go ahead and put that in the chat, or we can raise your hand and we can unmute you.
Yeah, I'm just looking at the chat box now. I had it, it wasn't visible earlier, but let's see. So yes, our services are free. We can't necessarily help all folks, like really high income folks. But we do our best to, provide referrals if we can't help folks out directly. Okay.
So I'll put again the link to the organization. Someone's asking about income levels for helping clients. What are your requirements around income?
We don't have like strict rules, but generally if you're super high income, we can't help long term, but we'll provide you with referrals.
What do you mean when you say super high income? Over 60,000, over 80,000, over what?
Well, I don't want to kind of give a strict guideline because it kind of is case by case, but what will have happen is you would call and do a brief intake, and we would collect information related to your income. But I would say that most people I talk to qualify for our services, and I've spoken to a range of folks with different incomes. Usually, like over 100,000, we wouldn't necessarily provide in-depth services, but we do try to do our best to help out in any way we can, and it's household income, not just your own income. So I see a question on the scenario with the landlord who set the rule that children have to be in by 5. Is that legal if it's for all tenants? I kind of don't think so. It would probably be an argument based on disparate impact. Like it might have a disparate impact on people with families. You have to, go and pick up your, children from school after a certain time, or from the babysitter. And so I know it's, things are different right now with COVID, but yeah, that seems pretty restrictive and severe. So my first inclination would be no, it's not legal, but yeah, it would probably be the argument based on disparate impact or potentially other legal arguments too, but it seems very restrictive, like restricting your ability to just move around or work. If you get off of work at 5, like it's not very allowable for you to live your normal life.
And in terms of housing, and as we move on into the pandemic with the CDC and the California state laws around eviction, do you post that information on your website? How can people get updates about that?
We don't. I'm not sure if it's up there, but I'll ask our executive director. I think that's probably a good thing to post. We do have our Facebook page where we sometimes post updates or news stories that are relevant to our work. But definitely with the COVID and eviction laws, I know there are lots of resources going around, and we're kind of trying to figure out our own thing. We did a presentation. I can ask Neva Elise, our supervisor. Well, actually, the presentation I did isn't kind of updated anymore, so that probably wouldn't be the best thing to post. But I would say follow us on Facebook. We regularly post there with information about our upcoming webinars. That way you can stay up to date, and then also sign up for our email list where we send around information about webinars, reports that we do, and that sort of thing.
And do you cover also Contra Costa County and San Francisco County?
Yeah, we help folks from all counties. So I see a question. Can you also speak about eviction laws for Contra Costa County and San Francisco County? I know less about the San Francisco County law. I know that there are a lot of organizations kind of focused on San Francisco County, so we actually don't get a lot of folks calling from San Francisco County. That doesn't mean we don't help folks from San Francisco, but Contra Costa, I believe their moratorium, oh no, I think it's still in place. It might end at the end of this month. I'd have to go back and look at the presentation I did for that. I believe it expired September 30th, the eviction moratorium. And I think it was for, the only exception was for public safety and health, but it's still complicated because we're trying to figure out whether California's law, which is more limited than the local jurisdictions, would kind of override that. But then the CDC has, from what we're understanding and learning, the CDC's eviction moratorium sets like a floor in terms of rights. So it says, essentially, from what I understand, that if another jurisdiction or your state law is more protective, then that jurisdiction would apply. But it's still, it's pretty complicated legally because kind of the way city governments or county governments and the state government interact with each other can get complicated, and trying to figure out when the state versus the county law overrides the other law is something that we're trying to just sort through.
There's a question about a law that states tenants' rights regarding landlords entering property with specific advance notice. That's kind of specific. I don't know if you know that.
Well, I can just provide some general information. So in general, yes, there is a law that says that landlords cannot just enter a property without giving notice unless there's like an emergency situation. But in general, they need to provide advance notice, I believe, at least 24 hours, but let me double check that. And it needs to be in writing. So yes, in most cases, they need to provide advance notice unless there's some sort of emergency. Can you speak about protections for homeless folks? Can you provide a little more specificity about your question? Yeah, we help homeless folks too.
Yeah, not sure. I don't think you have housing resources. I think you mostly help people that are already housed.
Well, we help people who are looking for housing. I've helped folks who are homeless, maybe they're couch surfing. Yeah, so we're happy to answer questions from folks who are homeless and provide consultation and advice. It kind of depends on what the issue is.
Excellent. And we have LaDonna raised her hand. Let's see. Can you help LaDonna unmute herself so she can ask her question? Let's see if I can do that. Let's see. LaDonna, can you speak? Try to see if you can speak. Now she seems gone. Having that problem. Okay.
I think she might have lowered her hand.
Okay. All right. Never mind.
Oh, another thing I meant to say, so during the coronavirus, I think at least until sometime in 2021, so you definitely have plenty of time this year, you can get your credit report for free every week from annualcreditreport.com.
From where?
Annualcreditreport.com, but be really careful because sometimes there are scams. So let me see if I can get the link.
Yeah, if you could put that in the chat box, that would be great.
Okay. Let's see, how do I try to not have it full screen? Do you know how to?
Oh, when you're sharing your screen, your chat box is up at the top, and there's a little 3 dots up at the top of your little toolbar.
Yeah.
And then there's a chat is one of the.
Okay, but how do, so I'm in full screen. I'm just, how do I get to a link? I just want to make sure I don't provide a link that's a scam, or I could send it in the materials afterwards.
Yeah.
I'll be sending an email with the links to the recording and a bunch of other links. So yeah, if you have recommended links to share out with the group, I'll add those to the list.
Okay, I'll make a note of that. But yeah, I would definitely recommend getting your credit report, especially if you're looking for housing. And for folks who are homeless, we definitely help them with their credit, issues and trying to read their credit report, because as I'm sure a lot of you know, credit, if there are issues in your credit report, the landlord might just deny the rental application immediately. So it's definitely helpful to know what's on there, and if there are any issues, to fix them as soon as you can.
Yeah, and again, we are going to have some more trainings with HERA, and when you fill out your evaluation, please put those requests in there. And I believe that state estate planning is one of the trainings that we're having. Someone recommended.
Oh, okay.
So I don't know what Credit Karma is.
It provides kind of like a summary of your different credit reports from the three credit reporting agencies. Experian, Equifax, and TransUnion. So it's not your full credit report, but it provides kind of the main components of it. Okay, see, I meant how the fair housing laws protect homeless folks. There's some discrimination. Yeah, so they would still apply as long as it's provision of housing. So let's say if it's the homeless shelter that's providing housing, or if the homeless person is looking for housing. As long as it's the person who is, or the company who's discriminating against the homeless person is in the business, quote unquote, of providing housing, it would apply. And that's, as I mentioned earlier, is a pretty broad category. Oh, Credit Karma gives you 2 credit reports and gives tips on how to improve your score. Yeah, so I didn't realize, okay, so maybe they do give your full report. Yeah, so I know a lot of our clients do use Credit Karma. It's just also good practice to get your credit report, especially now since you can get it for free. Normally, you can only get it once a year for free. So definitely, while you can, get it now. You can do your taxes for free with Credit Karma. I didn't know that. Interesting.
Yeah, for people, there's also low-income tax preparation available, and as we get closer to tax time, we'll be having that information for people too. So, well, great. Well, if there are no other questions, I hope you can join us at the virtual office hour this coming Monday at 10 a.m. on the 14th. And thank you so much for joining us today, and thank you, Nisha, for providing your information, and we'll look forward to having you back on some of these other titles.
Yeah, me too. Thank you, everyone. I'm glad you could make it. I enjoyed presenting and talking through these issues with you all.